Can your bank account or wages be garnished for old debt? What should you do? Brought to you by yourlegaleg.com, your advantage if you are being sued by debt collectors. Can your bank accounts be garnished by a debt collector? What about wages? Here are some things you need to know about garnishment. If you have assets, and this includes either a job or money in the bank, you must be concerned about the possibility of being garnished if a debt collector or anybody else has a judgment against you. In other words, the answer to our question about whether your wages can be garnished is yes. Wages can be garnished once a debt collector has a judgment against you. Bank accounts can also be garnished. When they are, it's almost always a surprise to the debtor. What typically happens is collectors obtain money judgments, usually by default, and then they use the judgment to freeze the funds in your bank account up to the amount of the judgment. State law and banking rules govern how the bank must handle the garnishment process, but don't expect any help from that. Collectors always notify the bank first, and then they notify the debtor. Of course, that makes sense. This way, your funds can be frozen before you can take any action, such as withdrawing all your funds. The problem here is that a lot of times, people don't even know there's a judgment against them. They've forgotten that they were served a lawsuit, or they were never served a lawsuit, and that's what happens when you get a default judgment. Their notifying the bank first is perfectly legal. You typically receive the notice, including your rights, a day or two or more after your funds have been frozen. During the time between the garnishment going into effect and your receiving notice, then, you may have written checks or made some other sort of transfer of funds. For most people, this means those checks will bounce, and you'll owe late fees, return check fees, and of course the original amount due, etc. The garnishment may not only freeze funds already in your account at the time of service on the financial institution, but can get money that you put in afterwards for a period of time. During the time the garnishment is in effect, the financial institution won't honor checks or other orders for payment if it would leave a balance under the amount stated in the garnishment. If they do, they're going to owe the money to the debt collector themselves, and they won't do that. When the amount being garnished is paid, the freeze on your account must be terminated, and automatically is. But since many people don't have nearly enough money in their accounts to offset any significant judgment, this is not of practical significance. Wages can also be garnished, and again, your first notice that you're being garnished, or even that there's been a lawsuit against you or a judgment, is likely to be when you receive a check that is less than you thought it would be. That can be a very bad surprise to people living close to the edge, as most Americans do, and especially those with debt trouble. Federal law limits the maximum amount that can be garnished by one or more garnishment orders to 25% of your disposable earnings for that week, or the amount by which disposable earnings for that week exceed 30 times the federal minimum hourly wage, whichever is less. In simple terms, disposable income is whatever money is owed after paying all required taxes and national insurances like FICA, Social Security, that is, Medicaid, and so forth. Personal tax and non-tax payments are about 15 or a little bit more of personal income, which makes disposable personal income about 85% of your income, maybe a little bit less. And there are state rules that are different that also limit garnishment. So if you are being garnished, your first action needs to be to check your state laws on garnishment and see whether there's some exemption that applies to you. Often there will be. Remember this, that in order for wages to be garnished, disposable income earnings must be more than 30 times the federal minimum hourly wage for a week. If you make less than that and don't have bank accounts that creditors could reach, you would be considered judgment proof. That is, they can't get anything from you. That's usually a bad status, but in this one case, it's a good thing. All the above being said, you will almost always be much better off if you don't let them get a judgment against you in the first place. So even if you're judgment proof, you don't want them to get a judgment against you. Things could get better for you in any number of ways, and just because things seem bleak now doesn't mean the sun won't eventually shine. You got to keep that in mind. and it isn't all that hard to keep them from getting a judgment if you know what you're doing. The sun eventually may come up. Make sure you're the one who benefits when it does and not some debt collector. Of course, if you're being sued, there's always a chance you could lose. Always a chance. That means you need to keep personal information about jobs and assets out of the hands of the debt collectors whenever possible. If you've ever written a check to the company who is the alleged original creditor, or of course the bank, the debt collector itself, you must assume the debt collector has your banking information. You might want to change banks. Garnishments are served on people, including corporations, not accounts. So it doesn't do any good to cancel your account and get a new one in the same bank. You got to get a new bank. Helping people is what we do. Protect what's yours and don't let the debt collectors rip you off. Take action to protect yourself from the debt collectors and help others do the same. Please like this video, share it with anybody you think could use it, subscribe, and comment, as all these things help others find our materials. YourLegalLegUp.com